Welcome back to Law News Network. I'm your host, Jesse Weber, and thank you for joining us. We're showing a replay today of the John Valerio case. Again, this is the case out of Las Vegas. John Valerio was convicted in 1988 of murdering Karen Blackwell, and now he is facing a retrial of the death penalty phase of this case after the Ninth Circuit Court of Appeals ruled that unconstitutional instructions were given to the jury, and they may have prejudiced the jurors to vote for the death sentence. The jury found the murder involved torture, depravity of mind, or mutilation, but the Ninth Circuit ruled that depravity of mind was too vague for jurors to understand. And in fact, the Nevada legislature actually eliminated this depravity of mind standard back in 1995, which was 15 years later on. And now what we see is, after a lengthy appeals process, that overturning of that death penalty phase happened in the early 2000s. After a lengthy appeals process, we finally see Valerio getting a second chance at the death penalty phase, even though he is guilty under the law. Just to give you a little background, Karen Blackwell was a prostitute in the company of John Valerio. Her body was found in the trunk of a car, wrapped in sheets from Valerio's apartment. Her blood was found all over his apartment, and he had her keys and address book in his jacket pocket. She was found stabbed 45 times, including in the genital region. So it's a horrific crime, and now we have a series of jurors trying to determine whether or not Mr. Valerio should spend the rest of his life in prison or be sentenced to death. He's already been in prison for 31 years. A little bit earlier, we had Adam Ghana on, reacting and talking and analyzing a little bit about John Valerio speaking to the jury, coming from his heart, telling them what he's been going through for the past 31 years, that he feels that he's a changed person, he's accountable for his actions. Will that be enough for at least one juror to say, I don't think that he deserves to die? They need a unanimous jury verdict, vote to determine if he should be sentenced to death or not. A lot of factors here. Not an easy case to discuss, but we have to discuss it, and it's important to discuss it. And here to help me talk a little bit about this case, I'm joined by criminal defense attorney, former prosecutor, and former Georgia State Representative LaDawn Jones. LaDawn, it's great to see you.
Thanks for having me on this morning.
Of course, thank you for being here. So, as I ask every guest that I have about this case from a general perspective, first thoughts about this kind of case. It's unique. It's been around for over 31 years. You're seeing a retrial of a death penalty case. First initial impressions.
You know, I am interested to see how a jury that is now surrounded with a lot of different technology and information that was around 30 years ago, right? So we're talking really about a good chance that it's the children and the grandchildren of the original jurors that will be making a decision in this case, right? And these are people who have grown up with the internet and social media and may have different opinions about the death penalty in general. And as you said, it only takes one juror to determine that I do not support the death penalty, and therefore I could not find it in this case to impose a life sentence or some other sentence in this matter. I'm pretty sure that the district attorney in Nevada, who is elected now, probably really knows whether or not the jurors in his jurisdiction are likely to find a death penalty. If he thinks that there is any chance that the sway of the people and the mind of his community has changed, he probably would not take the time, money and energy and resources to continue to put up a death penalty case for the jurors to make a decision on. Instead, he would simply offer a life sentence and a plea in exchange for going through it again. So I imagine that it is going to be interesting to see if the district attorney evaluated his community right to determine if 30 years later there's still support for death penalty on a case like this.
You know what's interesting is when you do a jury selection process and you try to find jurors that not necessarily would say, I will convict anybody who committed a crime, or I'm not sure about it. You try to find someone who's in the middle ground saying, I could sentence someone to death if the appropriate circumstances were correct. At the end of the day, when you are actually sitting on that jury and you have to hear this testimony and you have to hear it from both the defense's side and the prosecution side, correct me if I'm wrong, there's a very strong difference between sitting in a jury box and trying to convict someone of a crime and sitting in a jury box and trying to sentence someone to death. You have more experience in the criminal field than I do, but I would imagine that that is a strong distinction, and it's not easy for one person to say that another person should be killed.
Absolutely. So there's a lot that I believe goes on in jurors' minds in this case, right? I find that jurors have an easier time in those states and jurisdictions where the judge gets to make the decision on the length of the sentence. When you take capital punishment out of it, because they can easily say, well, yes, I believe that this person, the facts have been proven to show that this person committed a crime, but I don't have to have any responsibility for the outcome. In this case, the jurors have complete responsibility. And then something else happens. When you're sitting in the jury box for voir dire and you're being asked questions, in your heart, you really believe I can be fair and neutral, that I can be unbiased. And then you sit down for days, hours, weeks of a trial, and you hear in very gruesome detail from the prosecution, every stab wound in this case, how the body was packaged and put away, and your mind starts to think. You get to see witnesses talk about, or victims talk about, the extent of the injury. And usually in these death penalty cases, depending on the jurisdiction, if it's not a bifurcated trial where you have a separate jury determine the death penalty, if the same jury who watched the trial is also a part of the sentencing case, they've seen this full case be laid out at one time, versus those cases like now where a completely different jury will be hearing the facts of a case that occurred a long time ago, and the trial will likely be presented differently because of the witnesses that are available. It makes it very difficult, even in that situation, to hear the facts and know for certain that you're going to be completely unbiased. And finally, because these jurors who will be making a decision in this case were not the same jurors who had to determine guilt or innocence. They're solely determining whether or not the death penalty should apply. It puts a whole different level of pressure on the jurors to consider the facts of the case.
You're absolutely right. I do want to talk a little bit about the law. Just from a general perspective, we talked about it a little bit here in the last week. When you have a bifurcated trial, okay, you have one set of trial to determine guilt or innocence, and then you do have a trial to determine whether somebody should be sentenced to death or not. Correct me if I'm wrong, can you just elaborate a little bit for our viewers? When you have the sentencing phase, determining a death penalty phase, the rules of evidence and procedure are a little bit different. Am I correct? Can you expand upon that a little bit? Because I think when we see some of this testimony, there was maybe times when you say, oh, that seems like it might be hearsay, or how did that evidence get in? Can you just elaborate on that a little bit?
Absolutely. So there's a couple of things. First is the issue of relevance. There are factors that may not be relevant to whether or not a person actually was at the location, committed the crime, had the weapon, right? Those are what the factors and facts that the state must prove at a general trial to determine guilt or innocence. But at the sentencing phase, and kind of what this case is about, the jurors are thinking of something a little bit more abstract, right? What was the mindset? What was the seriousness of the case? Did this cross the line into a heinous case that death penalty should be reserved for? And because that is the issue, relevant facts and relevant factors about the defendant's background and childhood, about the defendant's background and childhood become more important. Hearsay and other evidentiary rules are usually relaxed, because what the statements or the testimony goes to is not just whether or not it would prove the case, but whether or not this case rises to the level, right? And so repeating what someone else said does not allow a person to be convicted on something that can't be proven. It goes to whether or not the jurors agree if this was a serious case. So there are a lot of evidentiary rules that are relaxed. There are witnesses that would not be presented at the guilt or innocence phase that are presented at the sentencing phase of a case like this. And at this time, depending on how the bifurcated trial goes, the jurors have heard a lot of the evidence that they need to hear in the guilt or evidence phase, so they open up something new at the sentencing phase. And
I would imagine one of the reasons because of this is when you deal with mitigating factors, obviously there's aggravating factors to determine if Valerio should be sentenced to death, and really the jury only needs to find one aggravating factor that is not outweighed by mitigating factors to find that he should be sentenced to death. But there's a term in the Nevada statute, and it's incorporated in federal law as well, federal criminal law, that any other mitigating circumstance can be considered by the jury. And we have seen all this testimony this past week put on by the defense. We saw a psychiatrist on just a little earlier ago. We're going to show more of that clip in a little bit. But we saw a testimony from a retired warden that oversaw the prison that John Valerio was at, testifying to what kind of prisoner was he. He changed in the 31 years that he was a prisoner. When he first came in, he was kind of getting into trouble. He was a young guy. Now you have somebody who matured. He got into less trouble, less violations, and trying to show him as a more upstanding person. He's changed the kind of person that he is. He's changed his character. So, and then we saw Valerio actually speak to the jurors. He actually provided a statement to the jurors saying, "I apologize on behalf of my family, my friends, Karen Blackwell, the victim, her family, her friends. I apologize to them. I'm a different person." When you see these kinds of other mitigating, this evidence towards these other mitigating factors, is that effective? Is that enough? Again, if a juror can find, at least one juror can find that all these mitigating factors to try and show that he is a different person than he was when he committed that crime, he might not be sentenced to death. What are your thoughts if that's effective or not?
Well, it has to be effective because that's really the only option that a defendant has. You can't relitigate the facts of the case that has already been determined. And in fact, if you attempt to relitigate the facts of the case, which many clients who are not happy with the outcome of the guilt or innocence phase want to do, that only goes to hurt the defendant. You don't want to talk about those things. You do, in fact, want to talk about their childhood and maybe experiences that they had that allowed them to have a less consideration for violent activity, right? Mental abuse and things that we know psychologically can change a person, maybe early introduction to things in their lives that change their way of thinking. So these factors must be shown. What jurors want to see in this case is, has this person's mind been changed such that we can feel comfortable that if he is given parole or if he's not parole eligible while he is in the jail, he will not be causing taxpayers more dollars, more death, more injury to people. At the core of things, I think that most jurors want to believe when mitigating factors are presented that they are in fact true. Now, here's again the difference and the uniqueness of this case. He's had 30 years to build mitigating factors, to have people from the jail to come and testify. When you normally have a case like this, you don't have that much time in between to be able to build up your reputation, right? It's only the time that preceded the actual crime that you usually get a chance to talk about. And so in this case, I think he may have the time factor, the appeals may have really heightened his chances of not getting the death penalty because he's had time to build up a good rapport in his jail community and to have people who are willing to speak up for him.
That's a great point that you made about that lapse in time. I wonder, do you think that was included in the jury selection process, a question sort of tailored to the fact that if someone committed a crime and there's been a span of years, do you think that person is capable of changing or not? I'm curious, do you think that was a question, or have you seen something like that tailored in a way where that might be a question that was presented to them?
I certainly hope that it was a question. If his counsel was doing their absolute best, as your viewers should know, jury selection is a good time to educate the jury about your case, to sway them to your side by giving them nuggets and factors, by appealing to their humanity, because that's the only time that you are really giving back and forth feedback from the jury throughout the trial. So I would have personally asked that question 3 or 4 times in as many ways as the court would have allowed me to get it in, right? Do you think a person over time could have changed their mind? Can jail help to rehabilitate a person's thinking? Do you think age is a factor that can change the way that a person responds to situations? And I would have continued to try to impress upon the jury through voir dire that it is very likely that my client has made it. Do you believe that that participating in, have you ever personally participated in jail ministry, right? And many of the jurors may not raise their hands, but now you've given them a preview when you put someone on the stand to say, well, he's been running the jail ministry for 20 years, right? And so I would try to get that out as many times as I could, and I hope the defense counsel in this case did as well.
I'm sure they did. LaDawn, I have another question for you. The reason we're talking about this case is because his sentence, his death penalty sentence, was actually overturned because of a standard, a jury instruction that was presented to the jury about depravity of mind, meaning that if the crime was committed with depravity of mind, then you could find that he should be sentenced to death. That standard has actually been eliminated by the Nevada legislature back in 1995. Thoughts on that idea of depravity of mind? It was too unconstitutionally vague. Would you agree? I'm curious what your thoughts are on that.
Yes, I'm so glad that the Supreme Court removed that language, and it took the Nevada legislature quite a bit of time to follow up on that change and employ it into their factors. I understand that there are a number of criminal defendants who were convicted using that same jury instruction in between the time the Supreme Court made the ruling and the Nevada legislature actually acted on the ruling. Depravity of mind is very difficult to describe to a jury. I mean, what does that mean? Most of the time when I have a jury instruction that isn't clear, what is, evidence that is direct evidence versus circumstantial, I have an example or a story that I can give them to help them understand that definition. Depravity of mind is a term of art that is very difficult for some. You would say if you stole candy from a baby, you have depravity of mind, right? What does that truly mean? So I agree. The Supreme Court did, this is one of those circumstances where I try to show people that our criminal justice system can work if everyone does their job the way that they were supposed to. It does work slowly, but the fact that at some point the Supreme Court was able to look at these laws issued by the states for jury instructions as well as for criminal penalties and say, you know what? We're doing an injustice to our community to allow people to be convicted on terms that we ourselves barely can understand and explain. If you cannot break down jury instructions to a level that a sixth grader can understand, the terms are probably not good and should be changed in all laws.
I agree with you. We're lawyers. We talk in legalese. It's a little bit complicated. Breaking it down for everyday people to try to understand. That's the important part. And to be honest with you, we don't even know what depravity of mind really means, because you commit a murder, obviously something is going on and there's something not right. I have a question before we turn to a clip, and hopefully we can have you here to analyze it afterwards. Some of the aggravating factors that we picked out, that we looked at the Nevada statute to try to see what they might be able to consider in determining John Valerio if he should be sentenced to death. There's if the crime was committed with threat of violence, torture, or mutilation, if it was a random crime with no motive, or it was non-consensual sexual penetration involved in this crime. From what we know about the case, we know that she was a prostitute. He was in contact with her. He was associated with her. I believe he was in her client list, her client book. He stabbed her 45 times in all different regions of the body, in the genitalia region. Based upon what we know, would you see that there is an aggravating factor here to find that he should be sentenced to death?
So the two aggravating factors that jump out to me out of the options are obviously the sexual intercourse, right? But the fact that she was a prostitute and he was in the client list kind of to help to cross that out. We always have an issue when we present cases, particularly when I was a prosecutor. It was difficult to present rape cases when the prostitute was the victim, because many times jurors don't understand that. The other issue would then be torture, right? 45 stab wounds sounds like torture. Well, if I were the defense attorney as I'm describing this, I would probably describe it as a loss of control at a moment in time, and try to prove through the medical examiner or the reports that the 45 stab wounds was something that was done immediately. Like these 45 stab wounds happened within a minute, which for me, I would describe as something separate from torture, right? I would try to show that maybe the stab wound that actually caused the death if the evidence supports that, was one of the first ones, right? And so the body was, the victim was already deceased, and the other following stab wounds was not, in fact, torture in the way that we would describe torture, right? In my mind, torture is hanging someone up and beating them and letting them suffer and then doing something else and allowing them to suffer. So I would really try, if my evidence supported it, to mark out those two things that sound like they are the most obvious aggravating factors in this particular case and show why they were not. It is definitely, with 45 stab wounds, I mean, that is just a very difficult mountain to climb. But sometimes there is evidence, and being very cautious and careful in your jury selection, that can make someone pull this out.
Exactly. And interesting enough, that mutilation part, that even if she did die in that first couple of stab wounds, you mutilate that body afterwards, that is perhaps rising to the level of one of the worst crimes. We sentence people to death in this country for the worst of the worst, and that is why you need a unanimous verdict. So it's going to be up to these jurors to try to determine whether or not he lives or dies. LaDawn, I thank you so much for being here. We have some clips here. I hope maybe we can have you on for a little bit longer. I was going to show the cross-examination of a psychiatrist that was brought on by the defense. Hopefully we can have you on to analyze it. This is the testimony of Dr. Norton Reutman. So we have LaDawn Jones with us. Let's see if we can turn to that clip right now, and hopefully LaDawn can stay on with us and analyze a little bit about the cross-examination of this person on the stand. Again, this is the defense's case. We're going to be hearing a little bit more from the live trial of Valerio a little bit later today. But in the meantime, let's take a look at this clip.
Things years before can in fact change.
Yes, providing that they have the character to do it. I mean, there's a certain number of people out of every 100, a certain small number don't develop the strong character or moral development that they need to do the right thing.
Then they have to want it, then.
They have to want it, yeah.
And if they don't want it, then it doesn't really matter.
Some people want to be resentful. They want to be the victim. They want to be angry. They want to show that they're strong. They want to feed their own ego. That's not what he wanted. He wanted to be better.
And how would you describe John now?
He's a peaceful helper. When he gets a chance to interact with others, they ask him, some of his peers say, how do you do it? And he says, you know, I just take a deep breath. I think forward thinking. I choose to be the type of person that I want to be. And then he enacts it. I think one of his peers said, man, you should write a book. Because he, when given the opportunity, if somebody's agitated or angry, upset, he has the natural ability to be there with them and then help them see it through. So he's like a natural peer counselor in the times that he's able to interact with his peers.
And that John Valerio could not have been 130 years ago.
No, that wasn't who he was back then.
But that's how you believe he is now.
Yes, after having interviewed him several times and looked at the confluence, what he says, how he appears, what his parents say, and how the records read, it all makes sense to me.
And so I think what you're telling us is you don't just take one piece out here and say 20 years ago this happened and another piece over there. You have to look at the overall development over the last 30 years.
That's right. I think there are very few people, including myself, where I could say 100% of the time I made the right decision, and I made no mistakes, that I didn't screw up.
And if you could go to page 18 of your report, and could you tell the jury what your conclusion is as a doctor of psychiatric medicine in Nevada concerning John Valerio?
To a reasonable degree of medical certainty, that means that I've used the methods of my profession. Based on the examinations, interview, and research into the adolescent development of the brain and review of the documents, I find John has redeeming attributes. He lacks characteristics of mental illness or psychopathic traits. He's developed into a pro-social individual who is not at risk to himself or others.
And that is your opinion?
That's my opinion.
Thank you, Doctor. No further questions.
All right, cross-examination.
Good afternoon, doctor. How are you?
Fine, how are you?
Good. You've testified in capital penalty hearings 20, 30 times, somewhere in that range.
Closer to 10.
How about you've evaluated 20 to 30 capital defendants?
Yes.
Is this the first time that you've evaluated a capital defendant 30 years after his crime?
No.
Have you reviewed defendants who have been housed like Mr. Valerio has been housed for the last 30 years?
Yes.
How many?
A couple.
Can you name any of them?
No. Names don't come to mind.
None of the names come to mind.
No.
When you were referencing all these defendants previously who had much more serious records than John Valerio, were you referencing the two that you can't remember now as you sit here? Did they have more serious records, or was their records consistent with the way that Mr. Valerio's records look?
Well, I was really referencing the hundreds of inmates that I've interviewed, not all of whom have committed capital crimes.
Okay, that's fair. You would agree with me that Mr. Valerio has been in a very particularized housing situation for the last 30 years.
Yes.
And you'd agree with me that the only real comparison you could do for that housing situation over the 30 years would be to other people that are similarly situated. Would you not agree with that?
I would agree with that.
And I'm asking you, since you said you one or two other people you've seen in a similar situation, how is it that Mr. Valerio's records match up? Are they consistent with it? Would you agree with that?
Could you ask me again?
Yes, for somebody who has been in his housing situation for the last 30 years, you'd agree with me that his records are fairly consistent with the other individuals that he was housed with,
Yes.
right?
Yes.
You would expect to see that maybe there's some problems until they learn the rules, and then eventually by 35, 40 years of age, you stop seeing violations. You agree with me?
That happens a lot, yes.
And that's a fairly consistent pattern for people who've been housed for a very long time in a particular situation.
Yes.
So let me go back to, you said you've testified a lot of times. Let's talk about some of the things you've sort of explained as your role. Today you got up there and you explained that you're a psychiatrist. That means you're a medical doctor, right?
Right.
And there are times when patients come to you and you're treating them because they're seeking help from you.
That's right.
And then there are times when you're hired as what has been referred to as a mitigation expert, correct?
Yes.
And in this case, you are a mitigation expert.
Yes.
And your role as you perceived it, as you've said in the past, would you agree with me, is to find something to help the jury decide to give a sentence less than death.
I don't see my assignment that way exactly.
How do you see your assignment, Doctor?
I see it's necessary to mine the records to look for facts that would support a conclusion, and that if it's not favorable to the defense can choose not to use me. So I don't have the intent to lighten up the sentence.
Do you perceive yourself as, well, let me ask this, do you perceive this proceeding as sort of a debate between two sides?
Yes.
Right, you said that before, right?
Yes.
And you perceive that the one side will present evidence through you, and then we will test it through cross-examination.
Yes.
Okay. Have you said in the past that, well, let me ask this. You've had a client before that you said was not motivated, correct?
I have had clients like that, yes.
And then specifically, so that we're all on the same page, Mr. Belcher.
Yes.
When you use the term not motivated, meaning he wasn't willing to help you provide information that would provide mitigation to his jury.
He didn't have the intent to reduce his sentence. He wanted to maximize his sentence.
And so during the course of your interview with Mr. Belcher, he told you, my mother never abused me, correct?
Well, Your Honor, I'm sure he can cross-examine it. Going into particulars of another case.
I don't want to go too far.
I'm
I
not
want
going
you to
too
have
far.
one more question here.
Yes.
And you had some information otherwise that suggested to you that he did, that he was abused by his mother.
I had somebody else's opinion.
And when you talked about he wasn't motivated, you were saying that's an example of it, that you chose to accept that his mother did abuse him as opposed to relying on his words.
No. I didn't reach a conclusion.
Did you provide that as an example as to why he wasn't motivated, that he told you his mother didn't abuse him?
He told me that he wanted to preserve his relationship with his mother, and he didn't want to use the court in any way to damage that reputation, that relationship.
Did you admit in Mr. Belcher's case that there are times that you choose not to put things in your report that are bad for the defendant?
Your Honor, once again, I think we've gone past the point with the Belcher case.
Well, this has nothing to do with Belcher, I'm just making sure that he knows what case I'm referring to.
I mean, this is relevant in terms of how the doctor either documents or doesn't document. And I assume you've got a good faith basis for going forward. Go ahead, I'll rule the objection.
That was a unique situation because my client wanted the client wanted to maximize his penalty, and he wanted to keep out of the report anything that would be contrary to his intent. So I was in a position where I would need to speculate, and there's no purpose to speculate. Speculation can come out during examination like this.
Well, during the course of cross-examination, you revealed information about your interview, correct, during that case?
Yes. Yeah.
And when asked why you didn't put in your report, do you remember giving the answer? I had to make some choices about what to put in and what not to put in, and I thought that that might be prejudicial.
Yes.
So you chose in that case to leave out information that was prejudicial to the defendant.
Yes.
In this particular case, you said you want, and let me ask, in any case, you want as much information as possible to make the conclusions you're going to make here, right?
I need sufficient foundation so that I can swear on a Bible and reach a degree of medical certainty.
And it's not like the patient coming to you. In this case, it's a forensic setting in the sense that you're seeking to find the truth, right?
That's correct. It's not my domain to find. I'm not a finder of fact. I'm not finding the truth. I'm conducting a psychiatric study.
And so when you said you gave the questionnaire to the defendant, there's no validity study or no reliability. You have to rely on what he tells you in these symptoms.
Yes.
Right? So when you ask the question, or do you ask the question of him, essentially, do you get very, very focused on horror films, pain or revenge?
Right.
You ask him that question, and he answers no, you accept that as true.
I accept that as his answer.
Okay? Well, is there any validation of this particular document in the sense that this is some sort of nationally known study that you conduct and give to the defendant?
No, that's like what doctors give patients to ask about their symptoms.
Right. I mean, you wouldn't expect somebody who's being assessed for mitigation in a capital murder case to say, yeah, I fantasize about pain and revenge all the time.
Exactly. The intent that a subject has to be factored into the evaluation.
And one of the things you ask is, for each one of these questions, now, past, or not applicable, meaning never, right?
Yes.
And in Mr. Valerio's questionnaire, you'd agree with me that some of these questions about sort of things that's happened in his past, he should have at least checked, well, in the past that might be true, but today it's not true. Would you accept that?
Ideally, every subject would be able to present their biography to me in detail. But my expectations of that is, my expectation is low. I rarely get a really accurate representation of a person's past and current symptoms from the checklist alone. It's just like a screening tool.
You would agree with me that in self-reporting, you have to rely upon the information being provided to you is in fact true.
Yeah, there is no, people don't come with a videotape of their lives. It's an interview-based procedure, much like law.
And much like previously, well, let me ask you this. You said you read the records, correct?
Yes,
And those are the Department of Prisons records, correct?
and yes,
And they're medical records, but they're medical records for the prison. Right?
that's right.
You read the, you spent 3 occasions speaking to Mr. Valerio, correct?
Yes,
And you talked to his parents,
yes,
his stepmom and dad.
yes,
You didn't talk to his natural mother.
no,
You didn't talk to his sister.
no,
You didn't talk to his stepsister.
no.
When, on direct examination, you provided an example about how a peer had told him that he should write a book about how he was able to do the kind of things that he did. Do you remember talking about that just a minute ago?
Yes, I do.
That's information that was got from Mr. Valerio, correct?
That's right.
You didn't go find the peer and ask him.
No,
You didn't talk to, Mr. Valerio told you that he has a good relationship now with the corrections guards, correct?
I didn't get independent verification of what he told me
Of any of this.
of any of this, except for the fact that the records that I reviewed was consistent with what he told me and was consistent with what his mother and stepmother and father told me.
Well, and let's talk about that, and I don't need to quibble, and I certainly don't mean to suggest that his mother and father are not being fully accurate with you, but the mom and dad did not report any major problems with Mr. Valerio between ages 13 and 18, right?
No, they represented him as willful, and his father did kick him out of the house as soon as he turned 18.
But
So-
not the same description as John Valerio gave you about the types of behaviors he was engaging in between ages 13 and 18,
That's right,
right?
that's right.
And it's not that necessarily mom and dad are not being totally truthful to you, it's their perception and memory that makes a difference, right?
Yes,
And there's not like an empirical data that you can assess whether or not which one is the more accurate. It's perception,
that's right.
right? So you talk to Mr. Valerio, and what, if I get this correctly, the main thing that seems to suggest to you that your opinion about Mr. Valerio is right is sort of that change in his records, correct?
I wouldn't depend just on the records. I depended on the 3 venues, the examinations repeated, the collateral interviews, and the records.
Okay. Let's talk about the John Valerio that was younger, as you said that was different, right?
Yes,
He engaged in behavior before age 15, and continuing on into adulthood that was criminal or otherwise against the rules, antisocial behavior.
yes,
Okay? That behavior at times was impulsive.
yes,
And that behavior at times, or even based on his own description, he was manipulative, correct?
Yes.
And you said that when he got arrested in 1986, his kind of persona, he took stock of himself, and from there it sort of grew into who he has become today.
that's what I said.
Okay. And while you acknowledge it wasn't an overnight thing, you suggest in your report that he expressed to you remorse for what he had done.
Yes,
John Valerio told you he's remorseful for the crimes he.
Welcome back to Law News Network. I'm Jesse Weber. You're watching the testimony of Dr. Norton Reutemann in the John Valerio case out of Las Vegas. This is the death penalty retrial case to determine whether or not John Valerio, who was convicted of murdering Karen Blackwell back in 1988, if he will be sentenced to death or remain in prison. To help me talk a little bit about the testimony that you just saw and a little bit about this case, I'm with criminal defense attorney, former prosecutor, and former Georgia State Representative LaDawn Jones. LaDawn, we were looking a little bit at this testimony of this psychiatrist, and besides the fact that he's got the look exactly of Colonel Sanders, I'd like to instead change the topic to the idea of, you're an attorney, you'd be doing a cross-examination of this man. He basically is a defense witness. I'm curious, how did the prosecution, the state, do at cross-examining him?
You know, he hit all the points that I would have hit, right? Making it clear, one, does he have a bias, right? Your job is to come into court to testify that this person would or would not be able to be a productive citizen. And so everything you say is going to go to that point. Is that correct? He did a great job at highlighting the fact that this is similar testimony that he's given in every case. In all of the cases, you speak to someone, they are doing better. So the prosecution is really trying to limit, because jurors, right, they want to hear from someone who they believe is neutral. And so the prosecution has to show, well, this person may not necessarily be neutral if their testimony is not in support of what the prosecution is saying. They also, jurors really listen to experts, doctors. You know, he has a degree, so clearly his Hippocratic oath will make him tell nothing but the truth. And it is the prosecution's job to show that even despite the fact that he is a doctor, his biases or his professional experience is such that he cannot be relied on in this case.
Exactly, because what he testified to right before the cross-examination was that in his medical opinion, John Valerio has redeeming qualities, no mental illness or psychopathic traits. And we're talking about a guy that committed a brutal murder over 30 years ago. And if he is in fact a different person than he is today, then does he deserve to die? LaDawn, you said a little bit earlier, and rightly so, that you have a different kind of death penalty case here because this is 30 years after the crime was committed. And you don't have necessarily the same man, so when you especially don't have the same jury determining who would determine his guilt or innocence, then determining whether or not he should be sentenced to death or not, when you have you could have an entirely different person who changed their entire life, things might be very different for a jury to find that he should be sentenced to death. And here, what the defense is trying to do again is put on some mitigating evidence, some mitigating factors, that even though there's strong aggravating factors in this case, when you look at the mutilation of the body, possible torture, possible sexual contact of the body, you have these factors. If you can show that, well, he was an upstanding citizen in prison, he has no psychopathic tendencies, he has no mental illness, he might in fact be not the man that you think. And again, it's going to be up to the jury to determine whether or not he should be sentenced to death. So my final question to you before we have to let you go is, what do you think is going to happen?
You know, this is a unique case, and so that's the question that the clients always ask, and
that's why I have to ask it. I have to.
Right. I have to give a lawyerly answer, which is, I don't know. It could be on either side of the case, right? There are a lot of, the time, I think, does play in the benefit of the defendant, because he can, again, present a case that he would not have been able to present 30 years ago. On the flip side, this is a heinous crime. And a very serious crime, and jurors don't care about what the changes in the law at the Supreme Court level were. They care about who is in their communities and causing these types of problems. I'm not sure what the Nevada statute and jury instructions say, but usually in these cases, the jury instruction is permissive, so and not mandatory. So it says the jury may convict based on these factors, and the jury may consider these factors. Not always necessarily that the jury must convict if must agree to the death penalty if these factors are in place. And so if the Nevada Nevada law is permissive, I think that there is a lot of room because of the 30-year window for them to say, you know what, I see some of these aggravating factors, but I also agree with the mitigating factors, and for that reason, I will not vote in favor of the death penalty. Hopefully the 30 years has assisted him in presenting this case, but for that 30 years, I think a death penalty, as we saw the first time, the death penalty would have been guaranteed.
I agree with you. I think if it was the timeliness of this and when it's fresh, he would have probably had a different consequence. So it's because of that constitutional challenge to that jury instruction that actually saved his life over 30 years ago. Now the question becomes, can the jurors unanimously find at least one aggravating factor that is not outweighed by any mitigating factors to determine if he should be sentenced to death? And remember, the mitigating factors are a little bit more broad, because the mitigating factors in the statute says any mitigating factor could be determined in this contemplation, this determination about whether or not he should be sentenced to death. LaDawn Jones, thank you so much. Oh, I'm sorry.
Thing,
yes.
If you have time, you
Absolutely.
know, the other interesting part of the time factor is, and this is not a probably politically correct thing to say, but many times when we presented cases where a prostitute or sex worker was the victim of the case, we always tried to find additional witnesses, because you almost needed 2 witnesses to collaborate for one person in the sex industry. And 30 years ago, that was probably the truth. Now, they are likely looking at the victim as just a woman, right? Even though I'm sure they know that she was a sex worker and they got that information, not nearly as much evidence will be presented about that 30 years later, which makes it even more difficult for the jury, and another factor to consider.
No, good point. Again, not easy for them to determine any which way. But LaDawn Jones, thank you so much for joining us. We really appreciate your insight, and we'll make sure to have you back on to talk about this case or another one that we're handling.
Thanks for having me.